Okay, we'll go ahead and get started, everyone. First, thank you so much for attending today's session. This session is part of a series of town hall sessions that we will have based on the recommendations of the DEI task force from this past summer. The community, members of the community were interested in learning more behind the scenes of how decisions are made. And so one of the recommendations was for the Office of General Counsel to provide an overview. And so we are thankful for Robin Parker providing this session today. We appreciate her flexibility. It is late in the day. I'm pretty sure many of you are also part of the conference today. So we thank you for your energy and being willing to stick with us a little while longer. I would like to also acknowledge my co-chair from the task force and partner on the implementation team, Dr. Vicka Bell Robinson. I see her picture here, so I'm sure she's waving at everyone. So with that, we will go ahead and get started. I would like to let you know that there's a Q&A chat, so if you have questions, you can type them there and we will try to answer those toward the end of or after Robin's presentation. So with that being said, Robin, I'll pass the mic over to you virtually and we'll listen in. So thanks again.
Great, thank you for having me. I appreciate the opportunity. With respect to questions, we will have a period at the end where you can ask questions. I do need to make it clear, however, that I cannot talk about any actual case at Miami or any legal advice that I may or may not have given to anyone. So with that being said, I will start the presentation. And my presentation this afternoon is really going to focus more on the First Amendment because that seems the most related thing that we do that is central to the task force work. So I'll start with the basic proposition that Miami is a public institution, which for all intents and purposes means we are the state of Ohio as a legal matter. So there's a difference with respect to the application of the First Amendment. The First Amendment of the United States Constitution applies to public institutions and not to private institutions. Many private higher ed institutions adopt some version of free speech as a matter of contract, but they are not constitutionally bound to follow all of the First Amendment case law. The private employers are not bound at all, and most of them do not have First Amendment policies that permit their employees to have free speech. So private employers can fire employees at will, typically, and if they engage in activities or speech that the employer doesn't like, they are free to terminate the relationship with the employee. That's not true with the university. As a public university in Ohio, Miami is represented by law, by statute, by the Ohio Attorney General. He is the statutory counsel to all of the public institutions in the state of Ohio. All of the campuses, at least all of the four-year campuses, have their own on-campus general counsel offices. All of the lawyers in those offices are assistant attorney generals. In my office, there are 3 attorneys and a paralegal. Mitch McCrade is the deputy general counsel, and John Woodard is the associate general counsel, and Amy Smart is our paralegal. Both Mitch and John are also AAGs, as you must be in order to represent an institution of higher education and give legal advice. There is no way we could do all of the legal work that Miami requires with just the staff in my office. So we use outside law firms. They're called special counsel appointments. When I want a lawyer to handle a specific matter or to address a specific issue, I have to go to the Attorney General's office and ask for a special counsel appointment. While I can recommend the counsel that I would like to have appointed, I do not control that process. That is controlled by the Attorney General's office. So having said that, we have about 16 outside law firms. They do everything from advise us on things like the First Amendment to handling all of our litigation, to FCC law. We have a public radio station license. We generate our own energy, so we have utility lawyers. Miami is in effect a small city. We have police. They are sworn police officers, so there are search and seizure issues associated with the police and other matters of prosecution of crimes. We have energy, we have students, as Vika well knows, and we have over 5,000 employees. And so there's quite a bit of employment law also. We do contracting. We do roughly somewhere over $100 million a year usually in construction. So we do a lot of construction law and real estate. So having said that, as I said, I'm going to focus on the First Amendment. So let me start there. So, and for some of you, if you were in this morning's session, some of this will be a repeat, some of it will not, and I apologize for the part that's a repeat. But public opinion surveys and other data show that most Americans, like most people I think on this campus, have two kind of polar opposite views of the First Amendment, and they hold both views at the same time. When you talk to people about free speech as an idea or a constitutional right, the vast majority of people are supportive of it. But if you ask them about a particularly controversial view or speech, then those very same people believe it should be censored. And those are kind of the space that public universities exist in. So let's see if I can advance the slides here. Okay, so the first area I want to talk about is harassment and stalking and our policies with respect to that. So speech that rises to the level of harassment or discrimination is prohibited under Title VI and Title IX. And the university is obligated to maintain and try to prevent sexual harassment, racial harassment, discrimination. So what is discrimination? What is it we're trying to prevent? So harassment is defined, and it's been defined by the Supreme Court as unwelcome, discriminatory, it's unwelcome conduct or speech, discriminatory on the basis of protected status, such as your gender, your race, your disability, sexual orientation, or age. It has to be directed at an individual or a group of individuals, and it has to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the university's activities or programs. So that sets a pretty high bar. And there have been differing levels of responsibility that have been tried, particularly with respect to Title IX. So under the case law with respect to Title IX, an institution can be held liable for student-on-student harassment if we acted with deliberate indifference, we had actual knowledge of the harassment, and our actions must have been clearly unreasonable in light of the facts. During the previous Obama administration, the Office of Civil Rights, which is charged with enforcing Title IX in institutions of higher education, changed the standard. And so they said we would be liable not only if we had actual knowledge of a violation, but if we should have known. So many institutions like Miami adopted mandatory reporting policies so that we would actually know if someone had made a report to someone of sexual misconduct. All of the efforts over the years to broaden the definition of harassment have failed. So a couple of universities, well, several universities, have tried to adopt definitions of harassment and discrimination that are broader than the Supreme Court's definition, and those have been struck down. The first one was of note was Doe versus the University of Michigan. This was in 1989. That time at the University of Michigan, their community was rocked with a series of racist events that had occurred on campus. Some unknown group of persons had distributed anonymous flyers around campus that had deeply offensive racial terms in them and declared open season. In another event, a student disc jockey allowed racist jokes to be broadcast on the on-campus radio station. And so when the community demonstrated against all of these activities, someone hung a KKK uniform out from a dormitory window. At that point, the University of Michigan put a group together and they enacted a policy that they hoped would prevent discriminatory hate speech on their campus. And the policy prohibited racist, sexist, homophobic statements. And it said that the policy prohibited speech which stigmatizes or victimizes an individual on the basis of protected group status, that has the effect of interfering with an individual's academic efforts. And the court ruled that that policy was overly broad because it encompassed protected speech and struck down the policy. The same thing happened in 2008 in the Dijon versus Temple case. Temple University had a policy that they tried to make broader than the legal definition of harassment by prohibiting requests for sexual favors or other expressive, visual, verbal, or physical conduct of a sexual or gender motivated nature when such conduct had the purpose or effect of unreasonably interfering with an individual's work, educational performance, or status, or such conduct had the purpose or effect of creating an intimidating, hostile, or offensive environment. And again, the court, while it recognized that some harassing speech may be worthy of First Amendment protection, and decided that the policy covered too much speech that was constitutionally protected, and that it was overbroad, and struck that policy down. In 2007, in a case that happened at San Francisco State University, the college Republicans challenged their policy as being overly broad on constitutional grounds because it purported to prohibit acts of intolerance. And the court in the San Francisco State case said, and I think it's worth reading, federal courts have consistently enjoined regulations in colleges or universities that purported to prohibit acts of intolerance or stigmatizing or victimizing individuals or group in specified categories, or insults, epithets, ridicule, or personal attacks. And this is how they concluded. While the courts have invalidated provisions like these, have expressed their sympathy, indeed their admiration for the goals or purposes that the challenged universities were attempting to pursue, those same courts consistently ruled the regulations could not stand, where their very existence would inhibit in some substantial measure the freedom of expression that the Constitution guarantees. And so there have been no cases that have upheld speech codes at universities in this country that I'm aware of. Excuse me. On the other hand, as I said at the start, we do have an obligation to maintain a living, learning, and working environment that is free from harassment and discrimination. And we do that through multiple efforts. Our DE&I training, our Office of Equity and Equal Opportunity, where individuals can go to file complaints if they've been, or reports if they've been harassed or discriminated against. In 2010, at one university, there had been anonymous offensive notes put into African-American students' dorm rooms, slipped under the door. racial slurs had been written on whiteboards and threatened African-American students who tried to sit near them in dining halls. And so the OCR at that point said that the stated misconduct need not be just directed at a particular student to constitute discriminatory harassment. The nature of harassment, the number of incidents, and the student's safety concerns demonstrate there was a racially hostile environment that interfered with the student's ability to participate in the school's education program and activities. And so the response for that or to that is academic education, training, DE&I activities in the residence hall, and other efforts to pursue education, particularly when you don't know who the offender is, in writing the threatening messages. So somebody asked this morning about cyber stalking, and harassment is harassment, irrespective of the vehicle you use to harass someone or stalk someone. So whether you do it electronically or face-to-face is unimportant if the conduct rises to the level of harassment and it's directed at an individual or group of individuals. Okay, so from there, let's move to what is protected speech. What that speech that the Constitution has said is protective speech. And so protected speech is hate speech. Protected speech is protests, and they protect the right of assembly to petition the government for a redress of your grievances. So when you think about BAM 2.0 and the petitions of their grievances, that's protected by the First Amendment. So hate speech is verbal, written, and symbolic acts that convey a grossly negligent assessment of persons based on their race, their ethnicity, their gender, their sexual orientation, religion, disability, or any other protected class status. And the United States Supreme Court has specifically and consistently held that hate speech may not be prohibited or punished simply because it's offensive. And that's irrespective of whether that policy is at a university or it's a city statute or a state statute. One of the most recent cases is a case called Mattal versus Tam, which came out of the United States Supreme Court in 2017. And at the center of that case was an individual had a rock band that he wanted to name the Slants. And the trademark office refused to trademark the name because it was offensive. And they had a policy that they would not trademark offensive names. And the Supreme Court overturned and struck down the trademark office's rule and said, speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought we hate. And so that's one in a long line of cases upholding the constitutional right to engage in hate speech. We're in what's called the Sixth Circuit. So in the federal court system across the United States, there are district courts in each state, and then there are circuit courts, which are the federal courts of appeals, and then there's the United States Supreme Court. So every state sits in a circuit. We sit in the Sixth Circuit. There are 12 circuits, and we're in the sixth. When you have a Sixth Circuit case, that law is binding on all of the people and institutions and employers in the Sixth Circuit. If a case comes out of the Third Circuit or the 11th Circuit, it's what's called persuasive. So, which means the courts should be persuaded by it, but they're not necessarily bound by it. But lower courts in the Sixth Circuit are bound by decisions of the United States Supreme Court and the Sixth Circuit Court of Appeals. And so last year, there was a case that was brought against the University of Michigan by a group called Speech First. And Speech First is a conservative speech group. And they filed suit and claimed that the University of Michigan's bias and bullying policy was unconstitutional because it offered no clear objective definition of the violations and covered protected speech. They also claimed that the university's bias response policy chills protected speech through its bias response team. So at the time the suit was filed, the University of Michigan made a number of planned changes to their harassment and bias policy, which apparently satisfied Speech First, but they continued on the claim with respect to the bias response policy, the response team. And so at the trial court level, the trial court refused to enjoin the University of Michigan policy and bias response team. Speech First appealed to the United States Court of Appeals for the Sixth Circuit. And the Sixth Circuit, in a 2-to-1 decision, ruled that the bias response team's ability to refer students to campus law enforcement if the reported bias had been a criminal act, or to refer cases to the student conduct office, or to refer students for mental health counseling is a real consequence, and that real consequence chilled the exercise of free speech. So what happened is it sent the case back down to the lower court, to the district court, to say, okay, now reconsider whether you should enjoin the University of Michigan's policy and bias response team. And instead of going back to trial, the University of Michigan settled its case, and as I understand it, dismantled its bias response team. It's fairly well known, I think, that hate speech is not consistent or congruent with the values of institutions of higher education, but that it is permitted. So the AAUP, which is a professional faculty organization, has a statement that they've adopted with respect to campus speech codes. And I will read you part of it. It says, these arguments, talking about speech codes, grounded in the need to foster an atmosphere respectful of and welcoming to all persons, can strike a deeply responsive chord in the academy. But while we can acknowledge both the weight of these concerns and the thoughtfulness of those persuaded of the need for regulation, rules that ban or punish speech based upon its content cannot be justified. An institution of higher learning fails to fulfill its mission if it asserts the power to prescribe ideas, and racial or ethnic slurs, sexist epithets, or homophobic insults most always express ideas, however repugnant. Indeed, by prescribing any ideas, a university sets an example that profoundly disserves its academic mission. So, oops, sorry. Navigating two screens is getting me. Okay, so I want to talk a little bit about what speech can be proscribed. So let's talk about Tinker and disruption and the heckler's veto. So there was a case called Tinker versus Des Moines, and for the first time, it took up the novel concept that students had constitutional rights. And that, as they famously said, students do not shed their constitutional rights at the schoolhouse door. But they limited that pronouncement by saying that schools could address speech that was substantially disruptive, that might start, that would disrupt the functions of the school. But they also said this: any word spoken in class or in the lunchroom or on the campus that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take that risk. So that was Tinker. And 3 years later, the Supreme Court decided a case called Healy versus James. And so the question was, does Tinker apply in the college context? And that answer has not been clearly stated by the United States Supreme Court. So you will find differing uses of Tinker across all the circuits, the federal circuits. Because Healy versus James said this, it said that they're not enclaves that are immune from the sweep of the First Amendment. It can hardly be argued that either students or teachers shed their constitutional rights, talking about Tinker. And then they said, where state-operated educational institutions are involved, this court has long recognized the need for affirming the comprehensive authority of the states and of school officials consistent with fundamental constitutional safeguards to prescribe and control conduct in the schools. Yet, the precedents of this court leave no room for the view that because of the acknowledged need for order, First Amendment protection should apply with less force on college campuses than in the community at large. Quite to the contrary, the vigilant protection of constitutional freedoms is nowhere more vital than in the community of American schools. The college classroom with its surrounding environs is peculiarly the marketplace of ideas, and we break no constitutional ground in reaffirming this nation's dedication to safeguarding academic freedom. So as a result of Healy versus James and the state of Tinker, there have been differing bodies of case law that have developed with respect to student speech at colleges. One of the most significant areas is that the courts have affirmed the ability of the institution and the academic programs to set professional standards and to dismiss students for failure to adhere to those professional standards, even if it involves speech. So one of the most interesting cases, at least to me, is a case out of the University of Minnesota called Tatro. And Ms. Tatro was a mortuary science major. Excuse me. And she took to Facebook and did quite a lot of speaking about her cadaver, Bernie, and things she wanted to do with and to her cadaver, Bernie. And she thought it was satirical and should be protected speech. And yet she was dismissed from the program for unprofessional conduct. The court upheld her dismissal. They rejected Tinker and said it did not apply, and that held that the university may regulate student speech if it violates established professional conduct standards. And that's true if in counseling cases, we've seen that where students refuse to adhere to professional standards of counseling, particularly if it involves discrimination, and that the courts have said that the students have voluntarily enrolled in the program, and so they don't have a constitutional right to refuse to comply with the professional conditions of those programs. And the reason that Tinker differs at the college level, and the courts have not set up two distinct tests, one for colleges, one for K through 12, but there's just, when you read the case law, there are very distinct differences. And the reason is this, and this is what one court said: the state does not require higher education, right? So you don't have to go to college. And so the state has much less interest in regulating the speech that occurs there. The students in colleges and universities are not children, but they are by law adults. And most critically, or most importantly, the mission of institutions of higher learning is quite different from the mission of primary and secondary schools. As courts have emphasized, the vigilant protection of constitutional freedom is nowhere more vital than in higher education. So even Tinker is limited in some ways at the college level. And then there's a line of cases called the heckler's veto cases. And these cases apply when you have a speaker who's been invited to campus. So if you remember a couple years ago when there were mass protest and disturbances at the University of California, Berkeley, because Milo Yiannopoulos had been invited to speak. The case law is very clear that if you invite someone to speak, you cannot let hecklers or protesters disrupt that speech and drive them off the stage. And that under the Constitution, there is no heckler's veto. So in the Sixth Circuit, in a case called Bible Believers versus Wayne County, the Sixth Circuit has expressly rejected the notion that there's a heckler's veto and that you can suppress or punish speech because of the likely reaction, even a lawless reaction of the listeners. And the court said, if the speaker's message does not fall into one of the recognized categories of unprotected speech, the message does not lose its protection under the First Amendment due to the lawless reaction of those who hear it. Simply stated, the First Amendment does not permit a heckler's veto. And so one of the most famous cases that you guys probably have heard about is the National Socialist Party of America versus the Village of Skokie, where the ACLU defended the right of the American Nazi Party to march in Skokie, Illinois, where a good percentage of the residents were Jewish, and a substantial majority of the Jewish residents had either been in concentration camps during the Second World War or had lost family in that process. So I'm going to move now to academic freedom, because people have lots of interest in that. So academic freedom is a special right of faculty and those who teach at Miami, that they have special First Amendment protections. And academic freedom is to determine who may teach, what may be taught, how it shall be taught, and who may be admitted to study. And all four of those categories, faculty play a role. They decide at the departmental level who may teach, right? They do the hiring at the departmental level. They select their own colleagues. They decide their own curriculum, what may be taught, what's pertinent to that program to be taught. And the individual faculty member decides how they shall teach their course. And the who may be admitted to study is a joint function between the university admissions program and then the individual programs that have admission criteria. I do want to make it clear, however, that not all classroom speech is protected. It's not an absolute right. There are no real absolutes under the First Amendment. Everything is a fact and circumstances test. You change a fact, you're going to change the outcome of a case. One good example of that has been occurring with some regularity in the news. Oops, sorry. Whoops. Well, that's not going to work. I am sorry. Last week in Central Michigan terminated a tenured professor and chair of its journalism department for using the N-word in class. And the university determined that he'd created a hostile learning environment in the class for his reckless use of the N-word, and he'd used other racial and homophobic slurs in his instruction, and that there was no pedagogical value in the use of the word. And so he had no defensible reason for using the word, and they fired him. Duquesne, which is a private institution, fired someone yesterday for using a racial slur in the classroom. But there's a 2001 case in the Sixth Circuit called Hardy versus Jefferson Community College, where a professor sued for being non-renewed for using the N-word in class. And the court ruled in his favor because the speech was, they said, germane to the subject matter of the lecture, which was on the power and effect of language. And so the issue, whether the case would be decided the same way or not today, is the language germane to the subject of what's being taught. Now, I think there's frankly probably a really good argument that it's never germane, that you can teach all you need to teach without ever using that word. And so what the court said is that Hardy's rights to free speech and academic freedom outweigh the college's interest in limiting that speech. So therefore he had satisfied what's called the Pickering test, which I'll talk about in a minute. Tenured professors have been fired for cussing in the classroom, when talking about their own sex lives in the classroom, and things unrelated to the topic that they are supposed to teach. Oops. Okay, so I'm sorry, I'm having trouble. Okay, so let's talk about public employee speech. So the question is, what kind of controls or limitations do you place on public employee speech? And so the first question you have to ask is the person speaking as a citizen, or are they speaking pursuant to their official duties? So under the Garcetti case, the law says, if you are speaking pursuant to your official duties, you have no First Amendment protection. The public employer can fire you if you are speaking about your public duties. Okay, but if you're speaking as a citizen, that is, you're not doing it in your role as an employee, then you go to what's called the Pickering-Connick balancing test. And when you decide about whether this public employee who is speaking as a citizen, the next question is, were you speaking on a purely private matter or a matter of public concern? And so what's a matter of public concern? A matter of public concern is the political, social, or other concerns to the community, or when it is the subject of legitimate news interests, that is a subject of general interest and value and concern to the public. So if you're speaking as a citizen, you are more protected than when you're speaking as pursuant to your official duties. And then if you're speaking on a matter of public concern, you will be more protected. If it's a purely private matter, you will not be protected. You will not, your First Amendment rights will not be protected there. And so then if you're speaking on a matter of public concern, as a public citizen, you engage in the balancing test. And so how do you balance those competing obligations, the employer's interest in disruption-free workplace and discipline-free workplace, and the public employee's right to engage in speech as a citizen on matters of public concern? And so the courts have come up with a three-part test where you look at the value of the speech, and that what they're actually looking at is, does the speech relate to a matter of political, social, or other concern to the community? Speech on political matters has the highest value, it has the most protection. So all speech that's political in nature is protected and will outweigh any governmental interest, whether it's for or against a candidate, whether it's subversive speech, whether it's on any issue that has been politicized like DACA or immigration, that have become partisan political issues. They look at whether the employer has a reasonable fear of disruption. There doesn't have to be actual disruption. It just has to be a reasonable fear of disruption. And when they're determining whether it's disruption, so what's disruption, right? What disrupts you may not disrupt me. But what the courts look at is, does it substantially interfere with the efficiency of the workplace or the university's educational mission? Can the person still do their job functions? Did it create significant disharmony within the workplace or safety concerns for students? And you cannot, and the third prong is, did the employer take the action based on the disruption that it caused or reasonably believed would have occurred, rather than in retaliation for the speech? So it can't be the content of the speech in that you're retaliating against the employee for saying that, it has to be based and focused on the disruption. So let's talk about that in the higher ed context. I want to talk about a couple of cases. The first is the Adams case out of the University of North Carolina. And Mr. Adams was a self-described conservative Christian, and he wrote on things which he described as the religious intolerance of public education. Many believed his views were racist, sexist, and homophobic. And when he applied for promotion to full professor, his colleagues denied him based upon his writings. The Supreme Court overturned it and said, even though he had submitted the writings as part of his official duties, that they were still protected by the First Amendment. They were not excluded by the Garcetti decision, and therefore he was entitled to promotion to a full professor. And that case happened in 2001. So from 2001 till just this past summer, Professor Adams was continued his course of conduct and behavior. And then it came to a head last spring when he made some fairly racist comments and in relation to being sequestered under the coronavirus limitations. And it just reached a boiling point at his institution. And so people were issuing condemnations, trustees were mad. The institution said this: hateful, hurtful language aimed at degrading others is contrary to our university values and our commitment to an environment of respect and dignity. Its appearance on any platform, including the personal platforms of anyone affiliated with the University of North Carolina, is absolutely reprehensible. However, no matter how upsetting and distasteful the comments may be, they are expressions of free speech and protected by the First Amendment. But they said this in the last line. They said, however, we stand firmly against these expressions of hatred, and the university is reviewing all options in terms of addressing the matter. So what they did was they reached an agreement with Professor Adams, who had 27 years of service, to retire, and they paid him $500,000 to retire in July. And then this summer, 2 weeks before he was to retire, he committed suicide. There's been similar events at the University of Indiana and with Eric Rasmussen, and I won't go through that, so if you want to read that, you can just Google it. But institutions have a right to free speech, and I think that's an important thing to say. And that's why you see presidents and others at institutions writing very vocal condemnations of racist and sexist and homophobic and other discriminatory hate speech. Last, I'll end quickly with staff. Staff don't have academic freedom rights. So in that respect, our First Amendment rights are like any other public employee, subject to the Pickering-Connick balancing test. But there is one exception, and that's the confidential and policy-making employees. So there's a class of employees under the constitutional construct that are called confidential and policy-making employees. And those employees do not enjoy as many rights as the regular public employee. And one of the cases that's in Ohio is Dixon versus the University of Toledo. And Ms. Dixon was the interim vice president for human resources at the University of Toledo. She wrote an op-ed that her employer, the University of Toledo, believed undermined its non-discrimination policies and procedures. The case went to the Sixth Circuit. Sixth Circuit found that she was, in fact, a policy-making employee, that she had the right to hire and fire and make employment policies, and therefore, under what's called the Rose presumption in the Sixth Circuit, that as a matter of law, her employer's interests prevailed over her rights to free speech because it deals with issues of institutional loyalty. And so because I know you want to ask questions, I'm going to stop there. So I don't know who's managing the questions or if there are any, but I'm happy to answer them.
Yes, Amy, did you want to? Or maybe she's not on here. Okay, so at least one question came through the Q&A box, and so this. Oh, okay. Someone else said something while I was talking. Sorry. It says, if a faculty member uses a racial slur in class, what is the reporting process for students in that class who might want to report the speech? How transparent is the university's process for investigating whether the speech is protected and where appropriate, taking action?
Okay. So that's a three-part question. So there are a number of places you can report. You can report to the chair, the dean, the Office of Equity and Equal Opportunity. That's probably the most, Kenya Ash and her folks, I know they're on the call, I think, is the most appropriate place. They will conduct the investigation. If they find reasonable cause to believe that the faculty member violated our policy of our policy prohibiting harassment and discrimination, the faculty member is then charged. That charge then goes to the Committee on Faculty Rights and Responsibility, where the faculty member gets a hearing before the Committee on Faculty Rights and Responsibilities. Those documents are all public. And so from what's transparent is you can read the final decisions of the committees on faculty rights and responsibilities, or if the case is appealed from the committee to the president, obviously, or even to the board. If you're firing a tenured faculty member, those are all public records.
All right, thanks for that. As we wait for any other questions, I'll ask two questions that came from the task force this summer that spurred this. So one has to do with, there was a request about hiring a Title, I want to say 6, maybe it was 7, but I don't remember exactly.
6.
I'm sorry, it was a Title 6, yeah. And so what is the Miami University ability to hire a Title 6 lawyer or an attorney, sorry?
Well, so there's no such thing as a Title VI lawyer. I mean, there are lawyers that practice in different areas, but a lawyer is a lawyer is a lawyer. Some have certificates in particular areas. We have just hired a new lawyer in my office who will be doing, focusing on Title IX, Title VI harassment and discrimination, in assisting both the Office of Equity and Equal Opportunity, Human Resources, and the Title IX office. So she will be joining us in the middle of November.
Thanks for that. And another question from this summer is, let me make sure. Sorry, I had them written down. Oh, so what are the implications of having a zero tolerance policy? That was something that came up. And so just your expertise and sort of where Miami is on that spectrum, because I know it exists on a spectrum, and so yeah. I'll let you respond.
Yeah, so you and I had a brief conversation with this, and I said, you can absolutely have a zero tolerance policy. It's just a question of what do you have zero tolerance for? And you cannot adopt a zero tolerance policy for protected speech. And that's what Doe, DeJohn, all of the hate speech cases, all of the harassment and discrimination cases stand for the proposition that you can only address that conduct and speech that rises to the level of harassment and discrimination. So it has to move into the area of unprotected speech. And then you can say, you could have a policy that said anybody that is found to have violated Miami University's harassment and discrimination policy must be dismissed. So whether it's a small infraction or a large infraction, you could theoretically have a policy that says they must be terminated, that the only sanction available is termination. But again, it must rise to the level of harassment and discrimination. It cannot be for protected speech.
Okay, and that is something that the task force wanted to look at, and we've had that conversation, in terms of where our institution is and where we would like to be, if that's something that the community is open to. So I appreciate you for explaining that.
I was going to say, yeah, there's lots of different models. We have one. Some schools have a model where the Office of Equity and Equal Opportunity, the institutional office that investigates, also hears the cases, tries the cases, and passes judgment. So it's, think of it as a single line, complaints filed with a compliance office or an Office of Equity. They do the investigation, they hold the hearing, they make the determination and impose the sanction. Here, what happens is we have a single office that does the investigation, and then the person goes into their existing discipline policy. So if you're a student, you go to the Office of Community Standards. If you're a classified staff member, you go into the classified discipline system. If you're an unclassified staff member, you go into the unclassified discipline system. And if you're a faculty member, you go to the faculty discipline system. So you could get rid of that construct and do it all out of a single office.
Okay.
Does that make sense?
Yes, that makes sense. Thanks for that. We did get a couple more questions, so I'll read this one. So it says, can you please go over the op-ed scenario and why the staff member was incorrect? I think that some staff members do feel empowered to write an op-ed, but given this information, I feel that their freedom of speech is being imposed upon, but I may be misunderstanding this.
I guess I'm not sure I understand the question. So the reason that the op-ed in Dixon versus Toledo, so the op-ed, so first of all, the editor of the Toledo Free Press wrote an editorial criticizing the University of Toledo for not giving same-sex healthcare benefits to all employees. Ms. Dixon wrote an op-ed saying that she took issue with the person who wrote the editor who wrote the op-ed because he had likened the denial of gay rights movement to the civil rights movement. And she wrote and challenged that assertion, and she said, as a Black woman who happens to be an alumnus of the University of Toledo's graduate school and employee and business owner, I take great umbrage at the notion that those choosing the homosexual lifestyle are civil rights victims. Here's why. I cannot wake up tomorrow and not be a Black woman. I am genetically and biologically a Black woman and very pleased to be so, as my Creator intended. Daily, thousands of homosexuals make a life decision to leave the gay lifestyle, evidenced by the growing population of PFOX and Exodus International, just to name a few. And so what the court looked at was her speech on a matter of public concern? Yes. Gay rights, domestic partner benefits, and then whose interest prevailed in the Pickering balancing test. And so normally when you speak on a matter of political issues like this, the individual employee almost always prevails. There's an exception to that. That's for I hate to say high level because I don't like that term, but for policymaking and confidential employees that they're going to lose because they owe a duty of loyalty not to go out and do things that undermine the mission of their employee, of their employer, I'm sorry, or to act in ways that would cause people to worry or to not be treated fairly. So what the courts have said is there's just like 4 categories, right? There's no clear line between what's a policy-making and non-policy-making position, but they've categorized them. So one position is positions that are specifically named by law that carry discretionary authority with respect to the enforcement of that law or the carrying out of some policy of political concern. So that's why you see every once in a while, you'll see police officers fired in instances where typical public employees would not be fired because they are charged with the discretionary authority to enforce laws. And if so, they're speaking in a way that goes against their employer's interest in a uniform and non-discriminatory enforcement of the laws, then they're going to lose that case, and the institution can discipline them. Category 2 is people who have significant discretionary authority that's available to the people in Category 1 that's been delegated to them, right? So in Ms. Dixon's case, the appointing authority was the president's. He had the right to hire and fire, and he had delegated that authority to her. And then Category 3 are confidential advisors, people like me, who spend a significant portion of their time advising people in Category 1 or Category 2. And it goes on and on from there. So it's just a very narrow, not narrow, but it's a small exception to the general rule that the interest of a public employee in engaging in speech on matters of public concern usually outweighs the employer interests.
Thanks for explaining that. And I'm not sure if you can, there's one more question and we'll stop with this one. I'm not sure if you can respond to it, but I'll at least read it and you can go on. So this person asked, I am curious if the incident uptown earlier this year with the professor and grad student would have been handled differently if the student was provoked to punch the professor because of the language he used. Again, I'm not sure if you can respond to that or not.
So I think I can respond to this without talking about I can't talk about that case, but there's a whole concept in the First Amendment law called fighting words that's not protected speech. And so it's the definition of fighting words is something that's addressed in a face-to-face context that would cause a normal person to have a violent reaction. And calling someone the N-word is a fighting word. So if that's the question, then yes, what would happen is they wouldn't be able to, they would be able to arrest the person for fighting words.
Thanks for that. That's all the questions we have right now. I'll give you a moment to finish up if you had any final words or thoughts. We certainly appreciate your time here.
This is really, I do want to keep emphasizing that the First Amendment is enormously complicated, that it's always effects and circumstances. It depends on who's talking, where you're talking, the circumstances, what you're talking about. And it's very difficult to just do things in the abstract or to say you can't do this and you can do that, because you really have to look at all of the relevant facts to determine if the speech is protected or not.
Yeah, absolutely. Yeah. Well, thanks so much. I know this is something that in the times we're in, and probably all times we'll be in, that people are interested in. So we certainly appreciate you being willing to come and chat with us and provide this information. We will be posting this information with the rest of our town hall so that people can have access to it. And so we maybe in a year or so we can have a different one if things need to be updated or whatever the case may be. But we really do appreciate your time and everyone's time for coming to join us today, asking your questions. I also would like to say thank you to Karen Conrad, who provided our captioning. We appreciate that. And so this does conclude this session for today. And just as a note, Amy had some technical issues, so sorry about the pause there earlier. These things happen. This is the world we're in. So thanks for your grace on that, everyone. Other than that, we again appreciate it, and we hope to see you at our next town hall, which will be in November with admissions. So thanks, everyone. Have a wonderful evening.
You too. Bye-bye. Thank you.
Bye.